Whopping 91% of Nairobi dwellers rent their homes. Now, with home ownership out of reach for countless Kenyans, being a tenant is an option many are forced to take to have a roof over their heads. Now, for the most part, the relationship between the landlord and the tenant is amicable if rent is paid on time and everything on the property works. But what happens when one party doesn't hold up their end of the deal? What if you are dealing with a tenant or landlord from hell? Well, tonight we demystify this very crucial relationship and fill you in on what you need to know to ensure the relationship with your landlord or tenant is one that benefits the both of you. Let me introduce my guests really quickly. To my left, I have Njoroge, who's a property manager with Regent Management Limited. Thank you so much for coming in. To my right, David Njoroge, property lawyer with Igeria and Ngugi Advocates. No relation. But thank you so much for coming in. So we asked the question for just some of our viewers to share their experiences as a tenant or a landlord. So we have Derek saying on Twitter, the eviction must be through a notice, because of course there's been a lot of concern about how evictions are carried out. Failure to provide notice renders the eviction unconstitutional. The acts and tribunals ensure the rights and responsibilities of both parties, landlord and tenant, are protected. So let me come to you, David, in terms of the role of the rent tribunal. What is it? Why was it put together, and what does it do?
Thank you, Vicky. The rent tribunal, what if I may start with a bit of a background as regards landlords and tenants. The particular problems you face with the tenants complaining about landlords' behaviors of closing doors at night, I'm sure you've seen a lot of complaints on your Twitter handle. Right. Goes across board, whether it's a low-income household or the affluent neighborhoods of this town. The problem is basically landlords and tenants do not have formal relations documented so that you can know who's supposed to do what at what time. Right. The only thing that tenants know is I have to pay my rent, and the landlord is simply receiving rent, and if that is not done, then the doors are closed. Now, where does a rent tribunal come in? The rent tribunal is a creature of a particular legislation known as the Rent Restrictions Act. It was an act created way back in 1959. It was supposed to deal with low-income kind of settlements. So the act provides that a tribunal will be formed to deal with any rent or tenancy disputes for properties whose value or whose rental value is below 2,500 Kenya shillings. Now, if you live in Nairobi, 2,500 shillings does not even cover 5% of the population. Right. So you'll find that the majority of tenants in any urban neighborhood in this country are way above that limit, and as such are not even under the jurisdiction of the rent tribunal. Right. Yes. So really, if you are above that bracket, is there anywhere you can go if you find yourself in a scenario where, for instance, you didn't get your deposit back, you know, which a lot of people have complained about? Yes. One, there are those who mostly go to the rent tribunal, despite the fact that they pay rent of higher than 2,500 shillings. The problem is that the tribunal has actually been taking in these cases and listening to them. And lawyers have tried, including myself, on several occasions, to raise objections that this tribunal cannot hear such a matter. You're representing a tenant or a landlord where the rent is 100,000 shillings. But the tribunal says no. We'll listen to it. If you have any problem, go to the High Court and raise your objections from there. But the High Court has pronounced itself several times and said that the tribunal does not have that jurisdiction. So you can either go to the tribunal, they don't have the jurisdiction, but you may be heard, or you can go to the other magistrates' courts and pursue your deposit return or any other dispute you have with your landlord through the courts. You can also go the arbitration way. Most formal tenancy agreements have an arbitration clause at the end as the way of dispute resolution. So you avoid the court process, which is a bit tedious. Then you take the arbitration process, which is shorter, a bit more expensive than the court process, but time efficient. Yes.
So let me bring you in, Jerry, when it comes to, because you also play the role of landlord as well. What are some of probably the more precarious situations you've had to deal with when it comes to a tenant, and especially, of course, in the residential part of things?
Thank you, Victoria. I would say that as agents, we come in to as an intermediary between the tenant and the landlord. And that is why he mentioned that in most cases you'll find that some of these issues that are taking place in the informal settlements. When it comes to the formal leases and formal tenancy agreements, there are covenants to which you stipulate the instances of whereby the tenant should pay the deposit, what should happen in the event that the lease is terminated or the tenancy agreement is terminated, requiring probably where the tenant is actually to do maybe the repair, the minimum repair works and all that. As a professional, I would say that we've tried as much as possible, because we are there to advise the landlord and we are there to protect the interests of the tenant as well. So that is where we come in between. In the extreme cases, where we are taking over probably a management whereby maybe a landlord may have tenants in place and maybe there's something that was really happening, there was no deposit, they come back and we advise accordingly, because we really have to protect the interests of the public, the general public out there.
Right.
Yeah. So I would say that tenancy agreements do come in handy in terms of stipulating what is actually required to be done.
Okay, and hopefully avoid what is in the next tweet I'm about to read. Hassan, who says, too often the landlord-tenant relationship is unbalanced, with all the power on the side of unscrupulous landlords. I mean, landlords unfortunately have a really bad rep when it comes to, dealing with receiving rent, making sure that the property is up to par. What would you say, David, is probably necessary foundational documentation that's needed before someone comes in, moves into a property? What should they know? What should be in place?
Let's start with the basic. You've seen an apartment, you like it, so you have a meeting with the property manager or the landlord themselves. The first thing you should have is a tenancy agreement or a lease, whichever you call it. It's basically the same thing, which stipulates one, how much are you paying for rent, how much is the deposit, what is the period of payment, is it quarterly, is it monthly, that kind of thing. What is the landlord supposed to do? Very important part. So we have the structural part of the building, which is supposed to fix, they're supposed to maintain drainages, they're supposed to make sure the structure itself is in good form, and that kind of thing. They're supposed to maintain insurance for the building itself. And the tenant is supposed to keep the particular premises in the same condition they found it by the time they're leaving, which is not the tricky part, because most tenants don't have any document showing what was the status of the apartment or whatever house it is when they moved in. So one of the most important documents is actually a checklist, which is supposed to be signed by both the landlord and the tenant, showing you're coming in at this time, this is what you have. All the taps are fixed, all the doors are in place, all the lighting is in place, so that when you are leaving, you have another checklist, which says this is broken, this requires painting, this requires fixing, and the cost of doing all this is this amount of money. We shall deduct this from your deposit and pay you the balance. That is not done, and that's why you have these problems every single day. And lastly, you must have a clause in the tenancy agreement stipulating how soon is the deposit to be refunded. If there's no timeline, the landlord can be making the house for the next 1 year. Easily.
So you have that issue of someone saying, I haven't been paid the deposit. I mean, so what do you do in that case where it just does not come at all? You've moved somewhere else and maybe there's nothing much to be done in terms of work or repairs after you've left, and you are entitled to the deposit, the landlord just disappears.
Well, I don't think landlords disappear. I think tenants just don't follow up, and they tire quickly because of the hurdles involved. So you go to your caretaker or the property manager, they say, hey, we are doing repairs, give us time. That is not an excuse. You're supposed to be able to follow up, but documented. Write to them, tell them, hey, I moved out last month. Where is my deposit? And if a particular timeline lapses after the stipulated timeline under the agreement, then you have a right to sue. And I have clients who have done that severally, and the deposit is returned.
Then hopefully you don't have to go to those lengths, you know.
Hopefully not, but now that means landlords have to be fair, for lack of a better word.
And I have to ask this, Njeri, in terms of raising of rent. There was a story that came out earlier this week in one of the local dailies talking about UN employees feeling that they were being taken advantage of. And many times you'll find people saying, my landlord just hiked the rent, without any notice. What is the right procedure to go about something like that?
Thank you, Victoria. With a formal tenancy agreement, there are usually provisions called escalations. For instance, if you're running a tenancy agreement for 4 years, there may be a provision of an annual increment, but this is based on the market dynamics. The problem usually is the tenants don't take time to read the agreements when they are signing in or when they are coming into the premises. And that is where you find that along the way, when you escalate, you find there's an objection. But the objection sometimes is out of maybe the ignorance, allow me to use that word, ignorance. Someone didn't take time to actually read. But increment should not just be, just be raised anyhowly. There ought to be a notice, probably justifying that. A notice of, say, 3 months, 1 month, depending, which has to be reasonable. But the best recourse is when you have a formal agreement. It's provided in respect to escalations, whether they are annual or once in every 2 years, such like. So that is a procedure. But the landlord may not wake up and say, maybe next week I'm just raising. It's not allowed.
I mean, and unfortunately, you find in areas where maybe it's low-income earners, they tend to bear the brunt of that kind of decision by a landlord. And you're thinking, someone who lives in a place where they will not be able to go to the local daily to talk about this, what are their options? Because that's majority of dwellers, especially in urban areas like Nairobi. What are their options?
Well, I think tenants, just like any other citizens, you cannot advocate for your rights if you don't know what your rights are. As Njeri has put it, the word to be used is the ignorance part. They just don't know. They simply don't know. And unfortunately, again, the balance between tenants and landlords, houses available and tenants who can take them up, is heavily tilted against the tenants. So landlords know they'll always get tenants. So you come in under their rules. So you have no option, either stick to the rules he has given you or go somewhere else. So how can you deal with it? One, sensitization of tenants or the general public as to what your rights are. A landlord does not have a right to just walk into your house and start, closing doors and all that. They need to know that. They just don't know it. Secondly, and this is probably the government's part, there needs to be more housing in these urban areas. So that there can be enough options for tenants to take up, and the issue of hikes of rent will slowly go down. And I think that's the effort which our good government and the president are trying to do at the moment with the affordable housing projects.
Exactly.
So probably that will sort it out.
All right, we have a caller on the line, Joe from Kino. Joe, go ahead. Good evening, Joe. I hope you can hear me. Go ahead with your question or comment. Okay, it seems that we have lost him, but again, you can keep calling. We have the numbers there on the screen that you can reach out to both our experts for your questions. There was also a concern earlier this year, and this was mainly a push by landlords who were saying any rent defaulters should be listed on the CRB. That had not gone through, but what would that do if it actually happened?
Well, it has not gone through yet because the people who are moving that particular motion, the Urban Landlord and Tenants Association, is awaiting for approval from the central bank so that they can be able to be linked with credit reference bureaus and start listing rent defaulters. It's still in process. It hasn't been approved yet. However, the same regulations, the credit reference bureau regulations, actually allow for third parties to list people with CRBs, but it has to be the approval of those parties. So if it's a tenant, you need the tenant's approval for them to be listed. What I have seen with the upscale neighborhoods is sometimes they have a form, a consent form, together with the lease, wherein you admit or you give consent that you can be posted if you default. So that happens.
It happens already.
It happens. It's already there, but it's a bit low. It's not yet very common. But if that happens, should the central bank approve it, then well, tenants are in a lot of problems because of that. But the bigger problem is the CRBs will list you even before knowing what exactly the dispute is. It's possible the landlord is at fault.
Right.
So is there a remedy for that if you are listed wrongly? Yes. You can easily sue for defamation if that happens.
Okay.
Yes.
Okay. Now, before I come to you, we have a few more comments on Twitter, feedback. Really quickly, let's look at the screen there. Twitter. Coming up, we have one from Hassan still. Too often, we actually looked at that earlier on. Let's move on to the next tweet as we get a question to Njeri as well. Mukuna is saying, I've heard people talk about the unrefunded lump sum amounts they paid for shops as well. How legal or illegal is goodwill? So I guess that has to do with commercial properties as opposed to residential. Have you respond to that, David? Lawrence saying, I just wonder who cares for Kenyans? Where are MPs to know their issues and pass legislations to protect us from landlords preying on Kenyans? Unfair rent rates, water, electricity and rent deposits not justifiable. Breakdown of sewer and drainage undone. We have a caller on the line, Jackson from Donholm. Jackson, go ahead. Thank you for calling. What's your question or comment?
Okay, my question is, there is a case where a tenant signs an agreement there.
Yes, go ahead.
Okay, can you hear me?
Yes, we can hear you.
Yeah, now there is this case whereby a tenant should give a certain notice.
Yes.
Give a certain notice. Okay, sorry. There is this agreement form that tenants are supposed to sign.
Okay.
I run a management agency by the name Quick Linker.
Okay.
And they normally give a tenant agreement form for them to sign in terms of vacation that they should issue a 1 month notice. Now there comes a case whereby a tenant comes to terminate a tenancy abstract, issuing notice, and it comes back requesting for the refund of the deposit.
Okay.
In that case, what's supposed to be done? Do you have to forfeit the deposit or should you refund the deposit to the tenant? I will fire a question to the lawyer.
Okay. So you're asking about notice and how long that should be when it comes to deposit also being paid out to the tenant if they're to leave?
Yeah.
Okay. So, David, I don't know if you want to take that really quickly.
Yes. To answer Jackson, it is not a legal provision. It is a contractual provision. There is no statute which says notice should be this month, this number of months.
Right.
It's not there. Only under the rent restrictions do they give a 1 month notice, but that again is for rents below 2,500.
Right.
But above that, it's a contractual thing. So if you don't have a contract, a tenancy agreement signed indicating how many months it is, then you're in problems. But if the question is how many months, then the reasonable part is 1 month. That is the basic.
But that's at the discretion of the landlord usually.
Exactly.
Okay.
Exactly.
Okay. Njeri, let me ask you this because people also were asking about eviction, maybe because they paid rent too late. There's also a manner in which rent arrears should be collected.
Absolutely.
How should that be done?
All right. They're usually expressed in implied tenancies or terms of the contract. And when I'm talking about where this expressed through lease agreement, there's usually a provision that the tenant should pay rent in advance.
Yeah.
In the event that that does not happen, then there's a provision whereby the Distress for Rent Act comes in. That is a legal provision whereby if, for instance, the tenant has not paid as per the agreed terms of the contract, a licensed auctioneer will come, they will distress the tenant, and they will give a room for about 14 days, upon which, if the tenant still does not redeem or does not pay, they will come and take away the goods. That is what is allowed within the confines of the Distress for Rent Act. So again, it will take about 7 days before the auctioneer or licensed auctioneer can sell the goods. Still, if the tenant does not pay, the licensed auctioneer will proceed and sell the goods to recover the rent. Right. So the eviction does not come immediately. Okay. There are usually legal processes, application for maybe a court order to do the eviction. Okay. That is as per the law. We have another caller, Peter from Kericho. Go ahead, Peter.
I have this small houses.
Yes. Yes. Hello. We can hear you. Go ahead.
have this small house, normally charge them 1,000 bob.
I beg your pardon, could you repeat that?
Yeah, I have this small house. Hello?
Yes, we can hear you. Go ahead.
Yeah, I have this small house. I normally charge them 1,000 bob. Yeah?
Uh-huh.
And there is somebody who has stayed there for 6 months and is not paid.
So you have houses that you're renting out for 1,000 and someone has not paid for 6 months?
Yes, yes.
Okay, so you're wondering what the procedure is to move forward on that?
Yes, exactly.
Okay. Yes. David, do you want to take that?
Yes, to answer Peter. Now, his houses now fall strictly under the Rent Restriction
Tribunal. Okay.
The Rent Tribunal, the Rent Restriction Act. Now, the good thing is that it is regulated. The bad thing is that he cannot move against his tenant without the authority of the Rent Tribunal. So he needs an actual order from the Rent Tribunal to evict this particular person.
Right.
So he's supposed to do a formal demand to the tenant to pay. If he does not pay, then he has to go get orders from the Rent Tribunal to either distress him or evict him, whichever one works. So yes, he has an option. He has options.
Okay.
And the good thing is that the tribunal sits in several towns across the country. All major towns actually have a rent tribunal.
Okay.
Yes.
And just as we wind up, Jerry, from your perspective as a property manager, and you now kind of act as a conduit between landlord and tenant, what should landlords do? Because we don't want to seem like we're one-sided against landlords, to legally protect themselves when they're getting into an agreement with a tenant.
All right. I think we are clear about the judiciary report of March, whereby I think most of the cases related to, filed to the tribunal. What has been happening is that the landlords are becoming more compliant. In respect to this, they want to formalize the agreement or the tenancies, have something in writing whereby it relates to the covenants of the landlord and the tenant. And part of the implied terms of the tenancy is that in respect to internal repairs, all that, they have to be done by the tenant. But the good thing that the landlord have done is that when you formalize that in writing, then you expect a very minimal problem at the end of the tenancy or when the tenant is actually moving out. They're following the due process of maybe Distress for Rent Act, because you, again, don't want to be caught on the other side of the law.
Right.
So yeah, they're doing formal tenancies and also following the distress for rent.
Okay. And David, just lastly from you, because I saw this also as a concern on social media, does a tenant have a right not to pay rent? Are they legally backed in any way?
No.
So if, okay, they have nothing.
Very unfortunate. A tenant cannot refuse to pay rent.
Okay.
If, and I've seen this before, if the issue is the landlord has not performed their duties under the tenancy agreement, say repairs and all that, you're actually allowed to notify the landlord that, hey, I have called you here 3, 4, 5 times, you've not come, I will do the repairs myself, and I will remove it from my rent. Now that can go through, but refusing to pay rent on the other hand, that's the easiest way to get kicked out.
Okay.
So you cannot not pay rent.
Okay.
Can
so
I just interject in relation to that? Again, what has been happening is that if a tenant does not pay and probably withhold, you go to court. There's a maximum of equity which says that he goes to seek equity, goes with clean hands. So you ideally have to pay and then go to court to seek redress if you need to. On the instances of whereby probably there's an accident or there's violence and all that, maybe a suspension in terms of the paying rent until that is an accident, say the property has been interfered with such that you can't really be there.
Right.
It can be suspended, but does not give a right for a tenant not to pay at all.
Okay, if there's nothing that you get from this conversation, don't not pay rent. Let's take a look at feedback on social media. LB saying, at Bahati, Nairobi, I paid 22,000 when I got in. The rent is 6,500, deposit 6,500, making it 13,000 shillings. I never understood the work of the remaining 9,000 shillings. So again, if it's not painted out early on, you can find yourself in such a scenario. Still on Twitter, we have Brian saying, when I got into a house in Ngong, it was not renovated. When I was leaving, my landlord insisted I renovate and even deducted my deposit for the purpose. I felt conned and almost committed a felony. Okay, we're glad that you did not actually do that. But as you said, David, that's not the purview of the tenant in terms of repairs. That should be the landlord.
You're supposed to leave the house in the same way you found it.
Okay.
Now, the problem is if you do not have any documentation showing how you found it, the landlord will say, I gave you a proper house. You are giving it back to me in disrepair, so I'm going to deduct your deposit. So that's always a fight between tenants and landlords. There is no documentation showing anything.
So oftentimes their word against yours.
Yes.
Okay, and the last tweet here from Professor Mwaniki saying, as a landlord, I have come up with a tenant-landlord agreement stating the rules and regulations of rent, increment notice, date of rent payment, and when to give a notice of vacating. All right, so of course they're protecting yourself from any eventualities later that could make the breaking of that relationship acrimonious. But thank you so much, David and Jerry, for coming in. Hopefully you learned a lot, but most importantly, be informed. Be informed before getting into an agreement, whether a landlord or a tenant, and ensure that you protect your interests. Thank you so much for watching. Keep the conversation going on social media. Have a wonderful evening. I'll see you again tomorrow night on Sunday Live.